The February 18th, 2026 Arlington County Board of Zoning Appeals is now in session. Good evening and welcome. I am Richard Kaplan, Chair of the Board. The board is made up of 5 citizens appointed by the Circuit Court. Tonight, in addition to myself, we have members Inta Malice, Judy Freshman, Carol McCoskey, and Alex Kumana. Also present is the professional staff, including Lindsay Klein, BZA Coordinator, Megan Ryan, BZA Associate Planner. Is Brett here today? No, we'll skip. And Stephen Rissy, Zoning Prims Supervisor. To avoid disruptions, we ask that you please place your mobile devices in silent mode. Before we begin tonight's hearing, I will discuss this board's powers and procedures for tonight's hearing. The board's powers are prescribed in the Code of Virginia and are set out in further detail in the county zoning ordinance adopted by the county board. The Board of Zoning Appeals does not have the power to rezone property or to amend the regulations set forth in the ordinance. That authority rests solely with the county board. This board does have the authority to do 3 things. First, the BZA can approve use permits that allow modifications of placement requirements for structures on 1- and 2-family lots where there is no option in the zoning ordinance to allow such modifications. In order to approve a use permit, the Arlington zoning ordinance requires that this board find that the proposal will not adversely affect the health or safety of persons residing in the neighborhood, will not be detrimental to the public welfare or injurious to property or improvements in the neighborhood, and will not be in conflict with the purposes of the master plans and land use and zoning related policies of the county. In making these findings, the BZA shall consider whether the modification will promote compatibility of the development with the surrounding neighborhood because of the structure's overall size, footprint, and placement are similar to those of the structures on the property surrounding the lot in question, and whether the modification will help preserve natural landform, historical features, and/or significant trees and foliage. When approving use permits, the Board of Zoning Appeals may impose conditions that it deems necessary and in the public interest, including but not limited to the duration of that use permit. Second, the BZA can grant variances from the specific requirements of the zoning ordinance. When granting variances, the burden of proof is on the applicant to prove by a preponderance of the evidence that the strict application of the zoning ordinance would unreasonably restrict the utilization of the property, and the need for a variance would not be shared generally by other properties, and such variance is not contrary to the purposes of the ordinance. Or the strict application of the ordinance would unreasonably restrict the utilization of the property, or that granting the variance would alleviate a hardship due to a physical condition relating to the property or improvements thereon at the time of the effective date of the ordinance, or to alleviate a hardship by granting a reasonable modification to a property or improvement thereon requested by or on behalf of a person with a disability. In all variance cases, the property for which the variance is being requested must have been acquired in good faith, and any hardship was not created by the applicant. That the variance granted will not be of substantial detriment to the adjacent property and nearby properties in the proximity of the geographic area, that the condition or situation of the property concerned is not of so general or reoccurring in nature as to make reasonably practicable the adoption of an amendment to the ordinance, that granting the variance will not result in a use that is not otherwise permitted on the property or change the zoning classification of the property, and that the relief or remedy obtained through the variance is not available through a special exception process as provided for under the zoning or subdivision ordinance. Third, the BZA has the authority to hear and decide appeals of the zoning administrator, or from any order, requirement, decision, or determination made by any other administrative officer in the administration or enforcement of Title 15.2, Article 7 of the Code of Virginia. Now on to tonight's hybrid hearing. For those who are participating in the room, in person, on the front table, you will find a QR code linking to a copy of the application package, including the staff report for each case before us this evening. For those participating virtually, a copy of each application package can be found on the Arlington County BZA website. There is also a link in the chat for the application packages. If you have not yet seen that report for your case, you should review that report before your case is called. If you are attending virtually and lose connectivity, please reconnect with us by phone. If you are attending via Teams, please keep yourself muted and cameras off until called upon. Turn off the sound on other devices around you to minimize interference. When called upon to speak, please turn on your camera and unmute yourself by clicking on the microphone icon that is located in the meeting command bar. County staff does not have the ability to unmute you. The meeting chat is active for technical support assistance only. The meeting chat should not be used for discussion, public comments, questions about agenda items, or requests for more information. All public comments must be shared verbally or have been previously provided in writing for the record during the assigned public testimony period. This evening, staff will call each case and will provide a brief staff report and recommendation. Next, board members will ask any questions of staff that they may have. Applicants or their representative may be given an opportunity to make comments to support the application or appeal. Next, all speakers for items will be called. Speakers must fill out a speaker slip online or is also available on the table in the front of the room. After we hear from speakers for and against the proposal, the board may permit the applicant a brief opportunity to clarify any points. The board may ask questions of any speakers, but will not permit any cross-examination or direct questioning by others. For tonight's hearing, this board has deemed the following time limits for speakers to be sufficient: 20 minutes for applicants of appeals, 5 minutes for applicants of use permits and variances, 3 minutes for representatives of organizations, and 2 minutes for individuals as sufficient. After the board has gathered all the information we need and have discussed the case, we will decide the matter by voting on a motion that is duly made and seconded. A majority of the membership of this board is needed to approve that motion. Please be respectful of the time allotted. This is a public forum, and tonight's hearing will be recorded and posted on the county's website. All information associated with tonight's hearing, whether spoken or written, is subject to the Freedom of Information Act requirements. Any appeal from the decision of this board must be made to the circuit court in accordance with state law. After your case of interest is heard, you are welcome to stay for the balance of the session or leave at your convenience. I don't have any matters to address, so I think we can call the first case. Ms. Klein.
Case number V-12082-25-UP-1, carry over and revised. A use permit request by Gerardo Perez on behalf of Forrest and Michelle Tatlock, the owners, to permit a rear setback of 18 feet to the porch, 16.9 feet to the porch eaves, instead of 21 feet to the porch, 19.5 feet to the porch eaves as required, regarding a new rear screened porch and landing to an existing one-family detached dwelling in the R6 zoning district on the premises known as 2612 North Pocomoke Street, Arlington, East Falls Church. Staff recommends that the board adopt the attached proposed resolution approving the use permit request, subject to the conditions listed. Note there is supplemental material for this case that came in after the application packet was assembled and printed.
Thank you, Ms. Klein. Do my colleagues have questions for staff on this application? Ms. Mellis.
It might be good if the supplemental material is described.
Can staff please describe the supplemental material?
Yes, the applicant provided a map of neighborhood outreach efforts and 2 petitions of signed support signed by 2 adjacent rear neighbors.
Thank you, Ms. Klein. Anything further, Ms. Mellis? Would you like to speak to your application? Can you, one, turn on the microphone, and if you need to raise the podium, I believe there are buttons somewhere on it.
Okay. Yes, my name is Gerardo Perez, on behalf of Forrest and Michelle Tatlock. So I want to thank the board and for helping us to carry this over for today, making some revisions. And we do agree with the conditions that the staff has recommended. And so I'm open for any questions that the board may have.
Thank you. Do my colleagues have questions for this applicant? Ms. McCoskey.
What are the approximate, I didn't see them on this one drawing, but what are the approximate dimensions of the porch that you're now asking? The setback's clear on there, but not the dimension of the porch.
Yes, it's going to
Just
be
approximately
8.9 feet deep, going towards the rear setback property line by 14. So 8.9 by 14.
Thank you.
Thank you. Anything further? Discussion with the board? Or someone, please feel free to make a motion.
I'll just make
Ms. McCoskey.
just note, generally I like to be crabby about these things. And I think there's no requirement that one should get to have a porch off the back of their house. But I really appreciate that the applicant has reduced the size of it, because when we saw it before, it was quite a bit bigger. And I think it's a very modest proposal, which also is affected by the slanted back lot line, so that the measurement of 22.8 is only at the far, only at one end of the porch, and the setback is greater at the other end. For those reasons, I'm willing to go ahead and support this proposal. And if
Mr. Chairman.
nobody has anything else, I can make a motion, but
Hey, Ms. Malice.
No, I was just going to make a motion if
great.
Yeah, I agree with Ms. McCroskey's comments, and I'm happy to make the motion. I move that the Board of Zoning Appeals approve the attached proposed resolution approving the use permit V-12082-25-UP-1.
I'll second.
Thank you. A motion for approval as advertised made by Ms. Malice, seconded by Ms. McCoskey. Is there any further discussion? Hearing none, I will call the roll. Ms. Malice.
Aye.
Ms. Freshman.
Aye.
Ms. McCoskey.
Aye.
Mr. Kumana.
Aye.
Chair votes aye. Motion for this porch passes as advertised 5-0.
Thank you so much.
Thank you. Ms. Klein, can you please call the next case?
Case number V-12083-25-UP-1, carryover and revised. A revised use permit request carried over from the December 18th, 2025 BZA hearing by Timothy Mock of Mock Architecture on behalf of Richard and Mary Micker, the owners, to currently seeking to permit a rear setback of 20.8 feet to the garage wall, 19.9 feet to the garage eave instead of 25 feet to the garage wall, 21 feet to the garage eave as required, to permit a left side setback of 13.3 feet to the garage wall, 2.8 feet to the garage eave instead of 10 feet to the garage wall, 6 feet to the garage eave as required, regarding a new two-story detached garage in the R10 zoning district on the premises known as 3930 North Upland Street, Stafford, Albemarle, Glebe. I'm sorry, I can't say that word. Staff recommends that the board adopt the attached proposed resolution denying the use permit request with conditions. An alternative resolution has been provided should the BZA see fit to approve the use permit request as advertised. Please note there is supplemental material for this case that came in after the application packet was assembled and printed, and the applicant provided drawings showing this request, their request here tonight versus a by right option.
Thank you, Ms. Klein. Do my colleagues have questions for this for staff?
Mr. Chairman,
Ms.
can I
Freshman.
just confirm that there have been minor changes, but the issue still is that it's 2 stories. Is that correct?
That is correct. Yes, it is still a two-story garage proposed.
Could I ask, and if you don't know this off the top of your head, I understand, but on page 5 of the staff report, you have these other accessory building rear and side setback distances. How many of those that were measured were 2-story accessory dwellings as opposed to maybe 1 or 1.5 stories?
Meg, do you recall that fact? Whether, if
Not off
not,
the top of my head, because Brett hadn't initially done that research, but let
Okay.
me look.
we can look into this. Yeah.
That's it. Okay.
Would you like to speak to your application?
I sure would. Yeah, it's on. Would you like a copy of the zoning code? I printed some extras regarding placement, and I've highlighted some parts because I think I'd like to reframe the discussion. I wholly disagree, and I've spoke to the professional staff by Zoom call with how it's being framed. So I prefer to approach this Socratically with me asking questions because there's clearly something I don't know. We are within the exception, 90% of the exception of, if we go through this, 3.26 placement, A setbacks, for all accessory buildings in, R10 district, save for the width of the dormer. That's all we really want exception taken to. we're under the heights, we're under this footprint, we're within this approved setback, but we want a wider dormer because, and this is where I don't want to get overly professorial, the definition of half story, and you can see this on the supplemental sheet, as well as the definition in zoning code, has a diagram. It's prescriptive design that is inadequately baked. It's not a fully realized prescription. It doesn't account for sloping lots. It assumes, though it doesn't say it, that you're going to have a quarter turn stair approached along the ridge line from the gable end of the building. We are approaching it from the shed side of the building. So I think we're asking for virtually nothing. And
Sorry, but just, so are you saying you don't think this is a two-story garage?
no, not at all. It's a half-story garage with a wider dormer than is allowed. And we're seeking relief from the 50% dormer. I think we have a 65% or 66% wide dormer, and that's evident in the supplemental drawing I've shown.
So, okay.
And the wider dormer makes it look symmetrical and prettier. That's sort of why you have prescriptive design that seeks, gable end buildings with dormers. It's, a traditional aesthetic rather than a modern one. We conform to everything but the dormer width. And that is because of site conditions and how you would approach this. And really, and I will get professorial, this is just inadequately thought, the term half story. It's not a half of anything. That's the problem. It's prescriptive design. And if you know what prescriptive design is, it's like urban planning at Seaside, Florida, where everything has to have a cornice or, et cetera. I'm fine with prescriptive design, and we are fulfilling all the requirements, but because of the way a garage door sits with a straight stair, which makes it easier than the prescribed quarter turn stair. And I mean, I really could get into the design critique of this, but I don't want to waste time. We're just asking for a wider dormer.
So I guess I would ask staff, does staff have any response to how they found it's a two-story garage? Because I think that's where we're between. Anyway.
Section 3.1.6 of the zoning ordinance states when a dormer exceeds 50% of the horizontal width of the roof, the dormer roof then becomes the main roof on that side of the building, and the building height is the vertical distance from the existing grade to the mean height level midpoint between the eaves and the ridge of the dormer roof. There's additional sections of the code that clarify that it does in fact mean it is a story, but that's what I found immediately upon review.
Okay. So does that not, I mean, I guess, I don't know what you're saying is prescriptive design. Are you saying that this provision that says if the dormer's a certain size, it's 2 stories?
There are multiple aspects, we could go through it. And again, it's easier to read it if you want. I have copies for everyone. But the whole point is that this has latent assumptions in it about sites. Okay. I mean, can I distribute
but
these?
we can't do something different than the zoning ordinance says.
No, you can. You can
Right.
provide an exception, right?
So this case is coming to us as a use permit. If you have a issue with the definition of a 2-story versus 1.5 story, then that could have come to us as an appeal, and then that you could have disagreed with the determination made by the zoning office. But that, in my view, that's not what is before us tonight. What's before us tonight is this compatible under the use permit standard? And in order to determine the compatibility on a use permit standard, the standards which is what I laid out at the very beginning of the hearing, one of which is compatibility with the neighborhood. And based on the staff report and the comparables that you provided in your response, I'm not seeing compatibility, because you're asking for something that doesn't exist in the neighborhood.
So because this,
so I mean, and my colleagues can disagree with that assessment of appeal versus use permit, but under a use permit, we have to go by the definition that the county board has given us to go by. We can't change that.
Okay.
And that's my view.
Mr. Chairman.
Ms. Mellis.
Yeah, I mean, any zoning ordinance is prescriptive. It has latent assumptions in it. And this is one of the latent assumptions. And I think it sounds like you're challenging the latent assumption.
Which the
Which-
proper venue would be an appeal.
Which we all can challenge all kinds of things, but we have to deal with what the black and white is.
I'm not experienced enough in presenting this. I haven't been before you that many times, and there have been non-conforming sites that you have approved. So I don't know exactly how to respond because we started out as a use permit and then this is a continuance, right? Should we, I mean, it would be detrimental to time and schedule to start the process all over again. Can this be continued under a different request?
Well, let me ask this. So to Lindsay, and I think we might have even asked this last time, if this garage met the 1.5 story or less, it's allowed to be here, right? It
Correct.
doesn't need a use
Right.
permit.
Correct.
Right.
So and I'm just going to try to get us out of a conundrum for this evening. I think what we need to do is perhaps we should defer this for another period of time for you to talk to staff about whether, or the zoning administrator about whether it's a 2-story garage or not. Because to us, it meets the definition of 2-story. And I think you technically agree to the extent that this dormer is, as you say, it doesn't meet the requirements for the 1.5. And I think you disagree that the dormer should, or the size of the dormer should make that difference in this situation.
That's basically it.
Right. So, but I think that's not something we get to decide. So I would say, and it's kind of up to you. If you want to request that we defer this, that is something that the zoning administrator has to decide in terms of an interpretation, is whether this is a 1 or 2-story garage. And I think the technical requirements that staff has applied mean this probably meets the technical definition of 2-story. And if, to the extent that the zoning administrator would find something different in a discussion of that issue, she might be willing, or her staff might be willing to say, you don't need a use permit, and then you don't need us to do anything at all. So I think, and that's up to you. If you would prefer to put it off for a little bit to discuss that, we could do that.
Well, I mean, I think that's obviously, I'm going to say yes to that, but the zoning administrator, I'm just curious, does that mean if she approves it or he approves it, I don't need to come back at all anyway?
Correct. That's
right?
exactly right.
But it puts it in the forefront of the discussion of, say, a building permit, right? Like she or he could approve it, and then we could go to contract to design a garage with engineers and such, correct?
That's a question for staff.
Well, that's, okay,
Yes.
go ahead.
Yes, I mean, it's a separate process. It's a separate application. You're applying for a zoning administrator termination. It's kind of an application you apply for similarly to how you separately apply for a use permit in this case. And so the result of that application would be a letter of determination, and that provides some formal recognition of the design you're proposing from the zoning administrator. And then that decision can also be appealable to the Board of Zoning Appeals.
Right.
There's always 2 aspects to the approval. One is the zoning. Is it going to meet zoning? And you've been told that because it's a 2-story, 1 under zoning, we have to approve it. But no matter what happened, you'd still have to go forward and get your building permit after engineering.
Oh, understood. I mean,
Yeah.
I am an architect. I guess I will accept it as a continuation, and we'll go to the zoning administrator to see if that person will approve it. It is an aesthetic decision, and it is when I say everything does have presumptions and it is a prescriptive design, This is also presuming all sites in Arlington are flat. Like there are things that,
That's the cards that we have to play with, right? I mean, that we have to go by the zoning ordinance.
right,
Right.
right. And I know that's why it's an appeal, but otherwise we're just doing it by right, however it shakes out. So,
And like I said, if
Mr.
you
Chairman?
challenge the zoning administrator's determination that this is not a 1.5 story, then that's also appealable to this board. And I don't know how that would turn out, but that's that,
I
right,
mean, we want to get a garage built at some point.
and that, well, but that's at that point, we can then interpret the ordinance. Under a
Okay.
use permit, I don't think we get to interpret the ordinance.
You don't get to interpret under use permit. All right. I did not know
At least that's
that.
my view,
All
right?
right. Okay.
Ms. Malice.
So the factor that determines that this is a two-story garage is the length of the dormer.
Correct, relative to the rest of the building.
How much shorter would that dormer have to be in order to make
have
this 1.5?
6 feet. 6 feet. It's currently at 20 feet, and maximum allowable to qualify would be 14 feet.
At this width?
Exactly.
Okay.
So we're here over the 6 feet. Is the answer to your question?
So it's 20 feet now,
It is 20 feet now, correct?
because that's your other option.
He's my client. You should come up if you want to speak.
So that's also you could move forward immediately
It's a smaller
without
one.
us
It's
if
just-
you change your dormer.
It's prettier if it's symmetrical, which is, I think, the whole point of the half story, but okay, I'll take it up with the zoning administrator.
So
How long of a deferral?
Ms. Klein, what do you think that, I mean,
It's really at the discretion.
no,
of the board.
how much, if this applicant were to have a
Realistically.
conversation on a determination with the zoning administrator, what do you think that would take? And you might not.
I am not aware. I'm actually gonna call Steven here to say if he has a sense of the application lead time for a zoning administrator determination. I don't know if Steven, you're able to speak.
We
now.
already have a March agenda.
New determinations typically have a 30-day turnaround time.
Did he say 10-day?
30.
30. Okay.
So we're looking at least 2 months.
April.
And I can answer Judy's early question. On page 5 of the staff report, all the examples for 1.5 stories are less in height.
I'm sorry, what was the last couple words, or less what?
Were either 1.5 stories or less in height, all those
than height.
examples.
Thank
Yes.
you. Right, and that's what I saw when I was just doing my reading of the staff report.
Mr. Chairman,
Ms. Malice, please.
in case V-12083-25-UP-1, I move that the Board of Zoning Appeals defer this matter to our April 2026 hearing.
Second.
A motion for a deferral to our April hearing made by Ms. Malice, seconded by Ms. Freshman. Is there any further discussion? Hearing none, I will call the roll. Ms. Malice,
Aye.
Ms. Freshman,
Aye.
Ms. McCoskey,
aye.
Mr. Kumana.
Aye.
Chair votes aye. Motion for deferral to April passes 5-0.
Okay, thanks.
Good luck with your conversations. Ms. Klein.
Yes. Case number V-12088-25-UP-1, a use permit request by Gerardo Perez on behalf of Dana and Alice Howe, the owners, to permit a rear setback of 18 feet to the deck instead of 21 feet to the deck as required regarding a rear deck addition to an existing one-family detached dwelling in the R6 zoning district on the premises known as 2133 North Pollard Street, Cherrydale. Staff recommends that the board adopt the attached proposed resolution approving the use permit request. Note that there is supplemental material for this case that came in after the application packet was assembled and printed. The applicant provided a petition of support signed by 5 neighbors, a map of neighborhood outreach, as well as a map of neighborhood outreach efforts, as well as text messages. There was also email and opposition letters provided from an attorney representing David and Janessa Hoffman at 2136 North Oakland Street, the adjacent rear neighbor. Please also note we have additional speakers signed up for tonight.
Thank you, Ms. Klein. Do my colleagues have questions for staff on this application?
Ms. Klein, I'm not sure if this is best directed to you or to the applicant, but I'll defer. I'm going to defer.
Anything further for this applicant?
For the staff.
For staff, thank you. Would you like to speak to your application?
Yes, hi, Gerardo Perez, here on behalf of Dana and Alice Howe. The owners are also online, would like to speak, but again, we do agree with the staff's recommendation of approval. You know, the owners have made some changes to the application before coming to here, removing some impervious lot coverage, so that way we can stay below the 40%. And so, again, Dana is online, and if it's the intention of the board to deny, then maybe we could defer the conversation to another day so we can make some changes.
Okay.
Yeah.
So, have you seen the feedback from the supplemental material?
No, I did not see any feedback from owner not being happy with the application.
Trying to bring it
the
up.
owner is online. Maybe he can speak on that.
I'm trying to bring up the supplemental now. 'Cause
I can't bring it up.
we're having some trouble
With
Right.
the,
seeing the
Yeah,
site.
get the staff report up.
I told Miss Ryan. Miss Ryan's working on it.
Thank you. Thank you for.
But we have the supplemental in our email, so I was just trying to bring it up. So that's why I was a little distracted.
I'm not getting the site. Are you? Who can fix this?
Okay.
Ooh.
Meg, would it be possible to screen share the comment letter on the screen? for
Yeah, I
everyone?
could do that.
Thank you.
But I think this is the case that I have a memory of reading, but I can't bring it up to confirm.
Yeah.
And if I remember, there was a lot of feedback from one particular neighbor, which I'm assuming is here. as
You
a
are
speaker.
correct. We'll provide that on the screen.
We can also move on to the speaker and then circle back if we need to.
Yeah, we could do that.
Yeah, why don't we hear from Ms. Huffman?
Okay, it came up now.
Oh, it's up now.
Yes.
Yeah, there it's.
Yeah, why don't we hear from, we'll hear from Ms. Huffman and then we'll circle back. Okay.
Good evening, members of the board. Aristoteles Cronus, counsel for David and Janessa Hoffman. Ms. Hoffman is here tonight as well, if you have any direct questions of her as well. But and
I'm sorry, can you identify the subject property that you are representing?
yeah, this is David and Janessa Hoffman are owners and residents of 2136 North Oakland. This is the property that is right behind the subject property, right behind the proposed rear deck addition. At the end of the comments, I think Ms. Hoffman will specifically want to address sort of the outreach issue because there's some little discrepancies with respect to how the outreach happened between the applicants and my clients, but I'll get to the substance of what we're here for tonight. We disagree with staff's recommendation and to approve this application for the reasons that were stated in the opposition that was filed with the board's part of record of your case. I would note that the few examples that staff identified of non-compliant rear yard setbacks, those were primarily from variances from 1972 to 2004, which were more liberally granted before Arlington created the use permit process. These are not really the best examples of the development in the surrounding neighborhood. What you really need to look at is the two properties that are right next door to this property. You have a smaller existing rear deck that's located at 2129 North Pollard Street, which is approximately 33 feet from the rear lot line. And then you have the existing brick patio that's at 2137 North Pollard Street on the other side of the subject property, which is approximately 28 feet from the rear lot line. So obviously under the circumstances, what we're looking at here is a significantly larger elevated proposed rear deck addition that's only 18 feet from the rear lot line that would not be compatible. We agree with staff that this application does nothing for natural landform, historical features, significant trees and foliage. Where we disagree with staff is this does affect health and safety and just impact on the neighbors. My client's property is 10 feet lower than the existing property. So now we're talking about a 12-foot deck that is going to basically overshadow their backyard. And if I may have a few more seconds. And also looking at outside, if you look at pictures that were submitted in what I submitted, you can see there's the view that's going up from ground level, which will basically show how this is going to dwarf their backyard view. And then also you're going to have, even from their bedroom window, you can see it's going to be looking right at this deck from my client. So that's going to be a consideration. Last thing I want to note, the development history of this property. 1969, there was a variance granted to this property that enclosed the front porch, made it into living space. That created, that's 17.7 feet from the front lot line. Now they're asking for 18 feet from the rear lot line. What happened in the middle was there was a massive expansion, 1,736 square feet in 2011 in the rear. So they basically maxed out this property, and now they're looking to get additional relief from this after, and the staff noted they're gonna have to remove a couple of items in order to stay under the 40%. So what we're really saying is, with everything that's happening here, this isn't, something where a use permit should be granted to a property that's already been frankly overdeveloped at this point. My client could speak to the outreach, because I think that's an important issue. I think that needs to be discussed here with the board. So thank you.
Thank you. Just very briefly.
My name is Janessa Hoffman. We live at 2136 North Oakland Street. I know there was something that I just saw this evening that was put in that there was no outreach. I think that was a copy of a text that included both the husband and wife of the property, Allison, I'm sorry, Dana. We had been talking, I just hadn't signed off on it. They stopped by my house multiple times. I have email exchanges with her where I say, I don't understand what you're asking. I don't know what's going on. I understand it was over a course of about 6 days. I don't understand. You stopped by on a Saturday. She asked me if I had any answers. My husband was traveling. I said, I haven't even had a chance to talk to him about it. He came back. I came back to her about 3 days later. I said, I am confused. I don't even understand. I don't know how to read this. She gave me an answer, but none of that they included. So I just want to make it clear we weren't ignoring them at any point. I didn't understand what they wanted, and we had to contact an attorney to figure out what they were looking to do. So this wasn't a question of us ignoring their request. It was, I just didn't sign it because I didn't understand what they wanted and I didn't know what our rights were.
Thank you.
Thanks.
I just a quick question for you. I get the sense that would additional conversations with your neighbor help come to a mutual resolution, or do you sense that this is not likely?
Respectfully, we understand obviously that they have a by right option right now of basically just making a deck that would come out not 10 feet, perhaps 7 feet. So we understand that we're talking about 3 feet, but that 3 feet as compounded with the elevation and the discrepancies, that's significant to my clients. So yes, if there would be a way to be able to redesign to mitigate those impacts, my clients would be obviously amenable to having that discussion with it, because we do understand that, yes, they do have a by right option of something that is less than what they're asking for now. So of course, but again, if it has to be an issue of either reducing the size, or primarily reducing the elevation, because that's really where this is going to impact my clients, is going to be the fact that, if it was ground level, it'd be a different story, but it's
right.
overall.
And I'll ask the applicant the same question, because if we have to decide, someone's not going to be happy, right?
So just to if I may, just to clarify, 3 feet of less depth, they would build it by right regardless of the elevation.
That's a question for staff.
That's correct. If they met the
Right.
21-foot setback, they would be okay.
Right.
So if I could ask,
Go ahead.
just to clarify on health and safety, how would the extra 3 feet affect health and safety?
No, in terms of the privacy at this point, right, every foot counts, because now you're talking about, if you look at the supplementary material that we submitted, you can see the pictures from shooting straight up from ground level. That wasn't even from the outside of my client's house. This was from their inside their living room, what they could see. And now you're talking any distance further back lessens that damage, right? In terms of, and particularly what you're seeing, what you can imagine right now is from their design is a 9-foot deck, 3-foot railing, but then that doesn't take into account what else could be put on there. For example, a patio umbrella, other things, anything that could add both visually, and then frankly, it's going to be a noise issue, right? Conversations, parties, whatever it is, right? Coming from that, any further back, I know, yes, you're saying it's 3 feet, but every single piece, every single foot counts in this, again, they're the ones asking for, some kind of a relief from what the norms would be here, which would be the 21-foot setback. So I think the burden frankly is on them to be able to justify why they can't because their neighbors next to them, right, are either farther setback or have smaller decks on both sides. And that would be more in keeping with compatibility of the neighborhood, to answer your question.
Ms. Malice.
So I don't know where I'm going to come out on this, okay? What is your range of options? Are you willing to consider anything greater than by right?
Well, I think the difference, and again, in sort of just speaking with my clients, I think the biggest concern is the elevation, right? So if it was something where it was, brought down, that might mitigate the circumstance. The other thing would be an additional tree screening condition, something along those lines. Again, thinking out of the box as to what could possibly be something on there. But again, we completely understand that they have a by right option, and this is really an application on the margins here. But again, when you look at this site and you look at everything that has been built on it throughout the years, at some point you have to ask, can this site even support what they're asking for at this point? And the fact they have to make other subtractions to make an addition, that's usually a telling sign that they're pretty much squeezing everything they can out of this application.
So in cases like this, where there's let's say a neighbor to neighbor dispute, and we do allow additional time, the intent is for the parties to come up with a mutually agreeable outcome, mutually agreeable. And if not, the case comes back to us, and then we decide, which way we're going to fall.
And which one side would not be, if we have to take a vote and decide, one side's not going to be happy.
Right.
Right. And so that's kind of the motivation here.
At this point, I would say, I don't know where I would come out. So you need to, and maybe my colleagues are the same, you would need to factor that into whether or not.
And my clients are open to that
Okay.
in terms of having that discussion. Again, I think what happened.
I don't think, it's good. I think we need to hear from.
The
owners to see if they're interested in the decision tonight, or if they're open to more conversation.
Is the applicant muted? No. I mean, the representative. Yeah.
So we're going to allow the owner.
The applicant is also trying to talk as well. So who would like to speak?
Yeah, I'm going to let Mr. Howe, Dana, take care of this.
You were muted a second ago. Do you want to try again? Nope.
Still muted.
Muted. We can't hear you. We can't hear you.
I don't know if it's is it at
No,
their end?
you are unmuted, but we can't hear you. There might be a problem with your microphone. If you want to try and call in, if you can't resolve it.
Okay.
He's calling. So I'll just, fill the quiet time is that I think this is a tough case, and I don't know where I'll come out. I think that the height of this deck makes it a little tough to find compatibility. And so I think that the rear neighbor has established a case that could challenge the compatibility with the height of this deck, because the comps in the staff report do not appear to support that. There's one of the three items are a deck, and I have not looked at the picture of that deck, but I'm assuming that it's not a 8 feet off the ground deck. The other comps are to buildings, which I don't think are extremely comparable. But so I would like to see the parties get together and see if they can.
Is the owner able to communicate?
Looks like he's not.
Not yet.
Yeah, so regarding, to this letter, so we were not aware that this, I don't know if the staff would be able to make that available to us beforehand. We could have, maybe been more
I'm sorry,
versed
having
on what's
trouble
happening.
hearing you.
Is that him right there?
I think the applicant is probably in the lobby now.
Okay. But again, I think it is a good idea if it is, if he's not able to speak, that we can.
Okay, can you hear us now?
Okay.
Yes.
Yes. Can you? Okay. Yep. Go ahead. Your computer's muted. So go ahead.
Okay. All right. Well, good evening. You have Dana Howe and Alice Howe. I'd like to thank the board this evening for considering our permit. And then as we look to address the comments that were brought up by Ms. Hoffman, we completely agree that every single foot in this case does count. And that's why we're advocating for a 10-foot deck versus a 7-foot deck, so we can maximize the enjoyment for our family, because in our current state, the yard, as the lawyer pointed out, is already developed, but it's not developed well, and it's not developed in a manner that which it can function for our family, which is why we're removing those elements of the yard in favor of a deck that will enhance the livability of our yard while also increasing our property value. We moved to the house that's most recent in July. So we're doing a handful of projects to get the property to make it ours and make it useful for our family's needs. I think it's also important to note there is a significant hedge that is between our property and the Hoffman's property. The hedge is at least 20 to 25 feet tall and is continuing to grow throughout the winter. So in terms of privacy, I think it's a significant privacy screen that affords both us and the Hoffmans significant privacy. And then as it relates to noise, a 3-foot difference, 7 to 10 feet in terms of sound propagation is not going to have a significant impact on, voices carrying things of that nature. So I don't necessarily agree with that conclusion, but I will agree that every foot does count. And in this case, a 10-foot deck offers the best use of our lot for what we're planning to do with our deck and getting rid of elements in our yard that do not support the functionality of our property. With that, I'm more than happy to answer any questions that you may have. Thank you.
I assume that you heard our previous discussion with your rear neighbor.
Yeah, we sure did, and we apologize for the audio issue there.
So from your perspective, would there be any value into giving you more time to have further discussions with that rear neighbor in order to come up with some mutually agreeable decision? Because as I said, I think twice now, if this board has to vote tonight, someone's not going to be happy, right? And so I don't know if it's a middle ground or not, but is that of value to you, or are you wanting us to make a decision tonight?
Yeah, it is of value. I guess my concern would be that at no point did Ms. Hoffman ever try to call us or reach back out to us. So I'm not going to make excuses either on my end or.
I don't think I don't think that this board really takes that into who said what or who's contacting who.
Right.
We require applicants to do the outreach.
Yes, absolutely, which we did thoroughly, and we did that in the month of November. So I guess I'm disappointed that we weren't able to come to a consensus sometime earlier. But it's well within their right, obviously, to hire legal counsel. But at any point in time, had Ms. Hoffman had those concerns, Alice and I would have been more than happy to discuss those, either over the phone, in person, et cetera. We made ourselves available. What changed from our perspective is after I consulted with Mr. Perez, and he said, well, that all signatures are not necessarily required, which is why we no longer pursued an in-person consultation with Ms. Hoffman.
Thank you. Miss-
I missed the part. Could you repeat the part about signatures no longer required?
So when we consulted with Mr. Perez about the neighborhood outreach form, he explained to us that the important part of that for the Board of Zoning Appeals, is that contact had been made. So with that in mind, since we had made physical contact with Ms. Hoffman once and then followed up, as she mentioned, with separate phone text messages between Alice and her, and then myself, Alice and Ms. Hoffman, that we felt that would be appropriate for the board's metrics.
Okay, thank you.
Anything further from my colleagues?
So
Ms. Mouse?
do we take it as there's willingness on both parties to discuss this further?
I think at least both parties are saying that at the outset. I don't know, I think time will tell, but so I would like to give them an opportunity. I know which way I'm leaning.
Mr. Howard, are you,
So-
is that correct?
Yeah, I guess my concern, right, would be that if we're asking to lower the elevation of the deck, right, so the challenge with that is the reason the deck is elevated to that height is so we can have a door that leads out to the deck. If we lowered the deck to say, 9 feet, right, I mean, there's a 3-foot difference between the deck and our door. So, I mean, that presents a serious safety hazard. And I just don't see that being reasonable. And it would also block the exits from our basement, both the windows and potentially the doors. So I think that presents a safety hazard as it relates to the downstairs. So it's not that we're willy-nilly, choosing this number. It's to conform with the existing design of the structure and the commonality of the neighborhood to match the.
Mr. Camano.
I think I know where I would come down. I don't think that it would. Regardless, I just want to clarify that they could build to the elevation that they want 3 feet shorter right now. I have concerns that the board is somewhat kind of implying that they should go back and negotiate with their neighbor on the height of this, where they don't have to do that. They could build it as high as they want to right now. And I'm never going to ask my neighbor on what I should do in my house. That kind of just defeats the whole purpose of land ownership at that point. And my concern is the elevation, the topography was always there, right? When they built the houses and these roads, the elevation difference was always there. It's not going to change. And therefore, like he mentioned, the height of this deck, he and they don't have to change it. So I'm concerned that we may be delaying their build or not based on something that they don't have to do. And I say that to say, if we want to vote no, that they need to build it 7 feet, I'm more amenable to voting no and having them start their project 3 feet shorter than implying they have to go negotiate something that they don't have to negotiate.
Well, I mean, but that's their choice, right? I mean, they could build the project tomorrow and not.
It's their
Right,
choice that
their
we're
choice.
heavily implying, and they,
And
they're
I think
going to
there
respect
there are other options than just the height of the deck, right? They can talk about size, they can talk about width, length, or screening, right? And so I, from my perspective, I'm happy to give them that opportunity. But Mr.
So,
Patrick?
yeah, so I would say that the disadvantage to the applicant of having us vote, should the BZA deny the approval of the use permit, is that if they wanted to come in with something else, they'd have to start all
Pay
over.
the fee again.
Pay a new fee and all. That's why sometimes we offer to, let people discuss it. But I think, yeah, the discussions would not be about height necessarily. They could be whatever. I will say, I'm not very close to supporting this because I think that house that is built out all over that lot, and I would think they could cut their deck size down to 7 feet deep and have something they could do by right, but that's their option. So I think the question is to the applicant, really, if the House would like us to vote, you might get a no vote and you'd have to start all over if you came in with a different one, unless you did something by right. So I would say we leave it up to them, because the discussions would be sort of for whatever options people want to consider. Slightly narrower, but not 3 feet narrower, something else. So I think we should make it clear, Mr. Kamana is exactly right.
Right.
We need to make it clear, this is not about you should make it a different height. That's
Yeah.
not what we're saying. We're just saying if you all could work it out and not have these arguments, then you might come back in with something maybe in a month that would be easy to approve without discussions.
It's also possible that they come back, everyone's in agreement, and we still don't approve it, right? So just because
Yes.
we're sending them back to
Yes.
for more discussions
So,
is not a foregone conclusion that this board would approve anything.
Right.
Right.
so, and I think that's up to the applicant to decide.
And that's to your point, Mr. Kamana, as well.
Absolutely.
And conversely, if the applicant chooses not to make any changes from their current design, that might be approvable as well.
Mhm.
So there's no
Right.
prejudice here one way or the other in terms of what we're going to do, and that's for both parties.
Right. It may, in full fairness, it may be very well that there's nothing this board would approve anyway. We don't know because we don't know where each other stands and we have not taken a vote.
And
Ms.
conversely,
Freshman.
yes.
Yeah, I would just say that I would approve it if we had an up or down vote. But I also think that if it turns out that they have to build it by right, they can still have a deck. It just isn't what they prefer. And we have people in here every single month wanting things that they prefer, like wide dormers, that aren't necessarily approvable. I would just point out that when you look at the tax map, the properties are not, they're diagonal. I mean, I don't know how to describe it. In other words, the
Right. It's not.
That's a great
That-
point, Ms. Freshman. Thank you.
the 2136 is when you look at the rear of that property and then where the deck would be on the applicant's property, they're not that close together. So as I said, if I had the option to approve it, I would approve it tonight. Otherwise, I think that it's not our job to design projects. It's not our job to waste anybody's time talking about 2 feet or 3 feet or whatever, or height, or the size of dormers. So I think that I'd like to see, some resolution. And I certainly would defer to the applicants who have more standing, I would say, than anybody else. Let's move on.
So I'm going to put it to the applicant as, you've heard the discussion, you've heard, ad nauseum. What would you like to do? Would you like us to vote or would you like for some time?
Yeah, so first, I just want to clarify. So does Ms. Hoffman have a recommendation or something in her mind already that she'd like to present?
We're not going to.
Yeah, I mean, that's something you could address. That's not going to be done
Okay,
tonight.
that's fine. We can table that. I just want to clarify for approval. So the 3 metrics that you guys use for approval is adversely impact health and safety, public welfare, and then conflict with the master plan. Is that correct?
And compatibility with neighborhood.
And compatibility, right? Okay. So, we've gone through painstaking detail with our contractor to design a deck that is compatible with the existing structure, that does not adversely impact, the health and safety, that's mindful. We're not asking to build this deck out to the property line, right? We're asking for essentially a distance that affords us the most flexibility to make that space useful, is what we're asking for. So, by all means, we'll continue to consult with the Hoffman throughout the construction process. About a third of their property backs up to our property line, with the 2/3 being the neighbor to their south. With that in mind, though, I think we'd be happy with a vote this evening.
With the.
A vote this
Vote
evening.
this evening.
Yes, thank you.
All right.
Okay.
I'll make a motion if you'll put it up on the screen, please. In case V-12088-25-UP1, I move Board of Zoning Appeals adopt the attached proposed resolution approving use permit V-1208825-UP1.
Second.
A motion by Ms. Freshman for approval as advertised, seconded by Ms. Malice. Is there any further discussion? Hearing none, I will call the roll. Ms. Malice.
Aye.
Ms. Freshman.
Aye.
Ms. McCoskey.
Because I find this, I don't think that this would be compatible with the neighborhood. And because something within the zoning requirements could be done, I vote nay.
Mr. Kumana.
Aye.
Chair votes no for similar reasons. I just don't find the height to be comparable, but it passes it passes 3-2. Good luck with your project. Right? I had that number right? 3-2?
Yep.
Yes. Passes 3-2. Can you please call the next case?
Case number V-12089-25-UP-1, a use permit request by Ranwa Nori on behalf of Jennifer Jones and Daniel Haldeman, the owners, to permit a left side setback of 7 feet to the building wall instead of 10 feet to the building wall as required, and to permit a total aggregate side yard width of 11.2 feet instead of 18 feet as required regarding a second floor addition over an existing non-conforming garage attached to an existing one-family detached dwelling in the R6 zoning district on the premises known as 44 North Oakland Street, Ashton Heights. Staff recommends that the board adopt the attached proposed resolution approving the use permit request with conditions. Please note there is supplemental material for this case that came in after the application packet was assembled and printed. The applicant provided a petition of support with 10 signatures from 9 surrounding properties.
Thank you, Ms. Klein. Ms. Ryan, can you please circle back to the existing picture? I missed it. Do my colleagues have questions for staff on this application?
I do have a
Ms.
question.
McCoskey.
So one thing that's bothering me a little bit about this is that the provision that says at the end of the ordinance requirements and providing that new construction may not take place over encroaching garages or porches, which is what we have here. Is that a placement requirement that we can amend? That's, I guess, I mean, it seems to me almost that that's a prohibition on something, and it isn't like a setback, which is a number of feet that we can amend by use permit.
It's trying to get that garage into conformance so they can then build above it. So by getting that encroaching garage and porch into compliance, then that would kind of get this into conformance. So that's what they're asking for that second story addition.
I'm sorry, explain how it gets it into conformance?
By bringing the garage into conformance by asking for the left side setback relief in the aggregate because that garage is already non-conforming. So to bring that into conformance, and they're asking for that second floor addition above it.
So they're not asking to build out over a non-conforming garage.
It would be bringing the garage into conformance to build that second story addition.
Sorry, I'm just confused as to what's happening. If anybody has a better, so do they have a garage now that's in the setback?
That's non-conforming.
Non-conforming, correct. And so it's encroaching.
Yes.
And so they're going to build over that.
Yes.
So how do they do that if new construction cannot take place over encroaching garages?
How did they get the first story?
The first story.
This was built in 1936.
Yeah. Based on the records I could find, it sounded based on the BZA minutes that there was some portion of the existing first floor and that at some point there was that prior variance that extended that first floor as well as added that porch on the basement level in front of the garage.
Okay. So we're trying to clean up an old mess.
Oh, so we're being asked to authorize the encroaching garage that was never approved in the beginning as
Legitimate.
part of what we're doing, as well as an addition over top of it.
Correct.
Okay, gotcha. Thank you. Sorry.
Anything further? Would you like to speak to your application? Sure.
Thank you, everyone. Just wanted to say we're trying to build a little bit bigger house for our growing family. I'm sorry. Oh, I'm sorry. My name is Daniel Haldeman. I'm the owner. My wife is away on business, so she's unavailable to join us by Zoom either. She's in a meeting until about right now. So we have a growing family. I have 11-month-old at home. We're just trying to make a little more room for our family, and building above this current office, which is above our garage, is really going to give us the maximum ability to make a more functional house for our family. And I'm not sure if, I hope you all clarify, the garage was original to the house, and then the office above it was added, I think, in the 70s. Yeah, it was approved in the early 70s. So I maybe I misheard that, but it sounded like you thought the garage was extra, but the garage, I think, was original with the building. I may have misunderstood that.
I apologize because I'm clearly the person who's most confused here, but what is there now? There's a garage. Is there a first story above it? And you want to put a
So
second
can we bring up
story?
the picture?
Yeah,
Either if I point
let's-
to the picture there. So picture on the
so-
left right there.
gotcha.
So there's an overhang and you can see the garage door and
Right.
and the trash cans.
So you have a first story, you're going to build above that.
Yeah, the part there with the bay window, that was above the garage. That is not original to the house because that wall there is external brick. And we'd like to build above all of that because having an addition over the top half, I think, would be very, it would limit us as well what we could do structurally.
That's fine. I just,
Yeah. Anything further for the applicant?
I have a
This-
question for Mr. McCroskey. Does there need to, do we need some clarification, or should we make some clarification over the fact that we're approving the non-conforming garage?
I'll look at the motion a little bit and see if I think we need to change something.
Okay.
I do wonder if this is better as come to us as a variance as opposed to a use permit, but I'm also not wanting to.
Well, yeah, I think.
I see what your point is.
But
right.
it's also not true that they just have a garage they want to build over. They've got part of their house as well.
And I did misspeak. It's not getting the garage into conformance. It's for modifications to that addition. And maybe if Stephen wants to clarify more.
That addition was granted under a previous variance.
There was an extension for the first floor that was granted on the
And
variant.
I assume that there's a condition on that variance that would prohibit building over it.
That's typically how it's done. I couldn't find the full BZA record for that, so I had to go based on the minutes.
So that's not on the record anyway. But I just wonder if this had, I don't know that I'm splitting hairs here, but just for the discussion, and I see Stephen's, Mr. Rissi's hand up as well. But I do wonder if since we're altering a previous variant, if this is not a better to come before us as a variance. Although, like I said, I don't want to penalize this applicant for that at the moment. So, is Mr. Rissi still hand still up?
Yeah.
Yes, it is.
Would you like to speak?
I would. I'd
Go
just
ahead.
like to clarify that they're not asking for relief from the exception. They are asking relief from the setback requirements for the side setback. That's why it's a use permit and it doesn't need to be a variance. We put the exception in the report only to clarify that typically additions above building walls don't come before you at all because there's an allowance for those to be built by right. This doesn't qualify for the exception because there is a garage below. And that is why this case for setback reduction is brought to you as a use permit.
So it's wholly a setback issue. The garage is just a red herring.
Correct.
Okay.
And I totally went for the red hair.
Thank you, Ms. McCusker.
Mr.
Alice.
So if there had been no garage, if this was house below, then it would not have come to us.
That's correct.
Correct.
Okay. So it's the fact that it's a garage. And why is that?
That's the county board made that decision.
Because the ordinance prohibits you from building over a garage.
Right.
So it's not within the exception for building above a story that you already have.
Okay.
Talk about a rabbit hole.
Well, I'm glad you brought it up.
Interesting
though.
rabbit hole, right?
Yeah. Thank you.
So would someone like to make a motion approving this?
Mr. Chairman,
Ms. Malice?
I move that the Board of Zoning Appeals adopt the attached proposed resolution approving use permit 1, 2, 089-25-UP-1, subject to the conditions listed.
Second.
A motion by Ms. Malice for approval as advertised, seconded by Ms. Freshman. Is there any further discussion? I will call the roll. Ms. Malice,
Aye.
Ms. Freshman,
Aye.
Ms. McCoskey,
Aye.
Mr. Kumana.
Aye.
Chair votes aye. Motion passes 5-0. We got there the long way, but we got there.
Thank you.
It was educational.
Ms. Klein, can you call the next case, please?
Case number V-12090-25-UP-1, a use permit request by Stephen Crawford on behalf of Mark Bolton and Nicole Joff, the owners, to permit a side setback of 13.3 feet to the building wall, 9.3 feet to the eaves, instead of 12 feet to the building wall, 21 feet to the eaves as required, regarding a new first story and second story additions to an existing one-family detached dwelling on a pipe stem lot in the R8 zoning district on the premises known as 2825 Lorcom Lane, Woodmont. Staff recommends that the board adopt the attached proposed resolution approving the use permit request, subject to the conditions listed, but please note that there is supplemental material from this case that came in after the application packet was assembled and printed, and that includes a BZA comment from Lucille Pafko, who is representing the adjacent neighbor to the north at 2824 24th Street North.
Thank you, Ms. Klein, as I bring that back up, because you said the address. North, okay.
Mr. Chairman,
Ms. Freshman, was it Ms. Freshman?
I'd like to disclose that I am acquainted with Mr. Eds, who is part of the team representing the applicant, but I don't believe that that association will impact my decision and consideration of the case.
Thank you, Ms. Freshman. My map, my flat. Is there, do my colleagues have questions for staff? Ms. Malice?
I think one of the people that wrote in mentioned topography. Is there we have a picture that actually indicates the topography to the rear?
I believe the best picture shows that existing west side elevation, particularly as shown on the screen here, the far left image here. The neighbor in question is located at the left side, to the left of that property from looking straight on this image. So as you can see, it is snowy, so it's a little hard to tell the topography, but in general, there is a slight slope upward from the subject property to their neighbor to the left.
There's a slope down from the subject property to the neighbor.
I believe it's a slope up.
Okay. And they're worried about runoff?
That was their comment, yes.
Okay. Oh, that's okay.
Would you like to speak to your application?
Sure. I'm Stephen Crawford. I'm the architect with O Design, and I am representing the client who is here. This is Nicole Jaffe. Her husband, Mark Walton, is also online. We are proposing to build a modest addition to an existing home that was non-conforming. It's a one-story mid-century modern house that was built in the 60s, and with the new zoning setbacks that have been adopted over the years, most of the house is in the non-conforming area. That one site plan on there that shows the pink box pretty much shows you where they're allowed to build as a matter of right. Most of the house, as I mentioned, is over the current setbacks. We are proposing a building over most of the existing house for a small second floor and expanding a one-story addition no closer than where the existing house is in relation to the property line out towards the west. So since we're building over existing walls that are over the setback and we want to have large roof overhangs because that's the current design of the existing house, we want to match that. We require a use permit for those overhangs, and since we want to extend the addition also within that setback, we needed a use permit for the one-story addition.
But you are extending the deck to the west.
There's also a deck, but the
Right.
deck, yeah, the deck is just low to the it's low to the ground. Correct. There's the current deck there now that we would just be kind of replacing and expanding just a little bit.
Thank you. Any questions for the applicant?
all of the neighborhood feedback is verbal, nothing in writing?
No, we do have sign offs. It's in there. Our client had met with many of the neighbors and they signed off on a few of those. And there were 2 neighbors that hadn't responded at all because they're probably rental properties.
But I'm reading it
Yeah.
sounds like from the comments that it's all verbal.
The last page has some emails.
It has 2.
Correct. It's Mark Walton here. It's all verbal based on our discussions. We haven't got signatures from the neighbors.
Mr. Chairman?
Ms. Malice.
A question for the applicant. Have you read the comment form that we received?
From the neighbor?
Yes.
Yes, we have.
Okay, so a couple of things. They talk about slope stability.
Yes. There is an existing detached garage on the uphill neighbor side. We interpret their concern is that as we're building the 1-story addition, as we're digging a new foundation, we would compromise that hill and affect their garage. Their garage is about 22 feet away from the house and from the addition. And we're only building a crawl space. We're not building a really deep basement. So with regard to the kind of the angle of repose that the county uses for identifying houses that may be built too close to one another and compromising the neighbor's foundation, we are well away from that. So we don't have any concern about that as far as building something closer to the garage.
And the other concern had to do with mature trees, canopy, and safety risks.
Yeah, so there's one tree in the middle of the existing deck which has to be removed because it's in the area where the addition is being built. There are 2 other large oak trees which are on our property. We will be evaluating those as we go further into the process. Our client would like to keep as many of the trees as possible. We're sure the other neighbors want to keep as many of the trees, but our client doesn't want these trees to fall on top of their new addition as well as the neighbor's garage. So if we find that the trees are in danger, they would most likely be removed, but we haven't gone through that process of evaluating those trees yet.
How far are those trees away from the area?
I would say the one tree is probably 3 or 4 feet off the property line, thus
on
our property. These are all on our property. Okay. But if the tree happened to fall down in any direction, yes, it could fall on the neighbor's garage, but they are totally on our property.
But they're not. It sounds like they're not close to the area where you're excavating.
Just the one right you see there in the middle, that one goes. The other ones are not near where we're excavating, but these are old trees.
Right.
And they've had some branches fallen. So if we think they're going to be a danger, our clients don't want to spend all this money to build a 2-story addition and then have a tree fall on their house.
And was there a conversation with this applicant prior?
There was a previous conversation with our client and the applicant when they reviewed the design. At that point, I understand the neighbor did not have an issue, but after I think they looked at it further in the last few days, they sent the letter over. I can't speak for them, but they sent over a letter to the county.
Okay, thank you.
You're welcome.
Discussion, motion?
Mr. Chairman, I mean, I think it's a very interesting property. And it sounds like you're going to keep it in keep the same style and that what accounts for the 4-foot eaves, which is kind of
That's
unusual.
correct. Yeah, this house has very large overhangs, correct?
It's a tough lot. It's a very tough lot.
I move that the Board of Zoning Appeals approve the attached proposed resolution approving use permit V 1209025 UP1, subject to the conditions listed.
Second.
Thank you. A motion for approval is advertised by Ms. McCoskey, seconded by Ms. Freshman. Is there any further discussion? I'll just say, because there was a neighbor in opposition, that I think that this is a very reasonable project given the unreasonable lot that we're dealing with. If this applicant were to bulldoze the house and try and build a new house, there'd be very little or nothing that can be built on that lot without coming to us for a variance or a use permit. And so I think this is a reasonable way to deal with that. You know, I guess if the applicant wanted to build a 2-lane bowling alley, they might be able to, but that's probably would also require something from the county board to allow it. So anything further? Hearing none, I'll call the roll. Ms. Malice?
Aye.
Ms. Freshman?
Aye.
She liked that one. Ms. McCoskey?
Aye.
Mr. Kumana?
Aye.
Chair votes aye. Motion passes 5-0.
Thank you very much.
Good luck. Ms. Klein?
Case number V-12091-25-UP-1, a use permit request by Steve Tinter of Cook Brothers Design and Build Remodeling on behalf of Margine Zawars. I'm so sorry about your Zaros. Okay. The owner to permit a separation of 6.8 feet between the detached accessory building and addition wall instead of 8 feet as required regarding a new rear addition to an existing one-family detached dwelling in the R6 zoning district on the premises known as 117 South Park Drive, Arlington Forest. Staff recommends that the board adopt the proposed resolution denying the use permit request. An alternative resolution has been provided to the BZA see fit to approve the use permit request as advertised. Note there is supplemental material for this case that came in after the application packet was assembled and printed. The applicant provided a petition of support with 5 signatures from 3 surrounding properties and a list of neighborhood outreach efforts.
Thank you, Ms. Klein. Do my colleagues have questions for staff?
I have a question. I don't know if it's to staff or to the applicant. So there's a landing that is the encroaching element to the structure, and the measurements at an angle.
Correct.
So I was not able to tell how far over would you have to move that landing or reduce its size to make that diagonal conforming?
The landing is actually okay because it can get a 4-foot encroachment. So that's meeting the setbacks. That's the building wall that needs the relief that doesn't meet the 8 feet.
It's the building wall. I thought it, but
Can it be either, though? Can't the landing get smaller or the building move?
right, because it was between the way I saw maybe I misread the plat, but I thought the measurement was from the landing.
The eaves and the landing are okay itself. It's the actual building wall that doesn't meet the 8-foot requirement.
And that's because the eaves qualify for an exception, but aren't really subject to this separation requirement, but the building wall is.
Right. I see. The dot goes to the building wall, not the landing.
Wow, how did I misread that?
So your question does still stand, I suppose.
Right.
It could be.
So what
moved in.
what would be the
Geometrically,
hypotenuse?
yeah, that would be more easily calculated with some software I don't have readily accessible. But potentially the designer would be able to answer that question if they're here tonight.
So we'll ask the applicant.
Would you like to speak to your application?
Yes. Steve Tinter couldn't make it tonight. So my name is Rob Hale, and I'm the architectural designer on this project. And I'm here with Ms. Wars, the owner. So as a member of an architectural review board in another jurisdiction, I'm respectful of the staff's findings. I tend to disagree somewhat. So as some background, the owner came to us with a larger addition proposed. And we counseled her on reducing the size. And in the end, we found that all she really needed was a sheltered way to get into her house from the driveway and circulation around the center stair that was to remain in place on the interior of the house. So what you see before you is intended to minimize the scope of what was originally proposed. And so it results in 1.5 square feet of encroachment at the 6.8 separation distance. Staff has cited two examples that are closer than the 6.8, one of which is 6.5. Granted, it's a second story, but the plane of a wall goes straight down to the ground. So that caveat sort of is not sure how to read that. There are also very few garages in Arlington Forest. And so there's no real precedent for this sort of thing. And one of our examples, there was a project that we did, Cook Brothers, on North Jackson Street, where a BZA, this board granted 6 feet of separation. Very similar, different neighborhood, very similar project.
Different neighborhood.
Yes,
So,
yes.
right.
That said, we endeavored to minimize the encroachment. We wanted to provide a responsible design that complements the neighborhood and enhances the value of the home. We humbly request that you grant us the 6.8 feet of separation. Thank you.
All right.
Ms. McCuskey.
Yeah, and I'm sorry, but because I feel like I don't understand anything tonight, but so I'm looking at the plat. It's page 14 of 35 in a set, but it's the one that shows in blue the new addition. And what I think you might have explained this, but I don't understand. So the problem is the 6.8 feet that's between the garage and that corner of the little 5x5 approximately piece.
Yes.
What is the purpose of the 5.5? Because I think this is
That's
what.
not a landing. I thought that was the landing.
Right, there's a landing
Oh.
outside of it, I think, but
Okay.
that's part of a building. So
Oh,
my question is, what's the importance of having that? It seems to me that could be reduced a little bit and you'd make it to the 8 feet. So I guess that's my question. Why is the necessity for having this?
Understood. So you're speaking about the wall line, not the land.
there's a little square there.
Right,
Right.
right.
So the wall, the
line.
yellow square represents a sheltered entrance. It is 4 feet out from the existing brick wall. And it is approximately 4 feet out to the AC unit. Can't go any further in that direction because there's an AC unit that's not moving. And
Okay.
we didn't want to increase the magnitude.
But
So-
that's a choice, though. AC units can move.
Yes, but
Right, no,
that
but,
adds cost. I mean,
but-
that would just make us non-conforming.
I mean,
more.
everything here has a cost, right?
Yeah,
That's-
yeah,
right.
but we would be non-conforming more. So the point is, we've reduced it down to its lowest possible size and in order to provide her access.
And as I look at the drawing that's up there, there are 2 doors from that entryway into the house. One
Correct.
that goes to, I don't have it on mine, but so there's 2 doors. So that's why you're putting this outside thing.
This node, it's a node, if you will.
Gotcha.
Yeah.
Okay.
So
Okay.
can I add, Mr. Chairman?
Ms. Malice.
So my question is the same. Now I understand. I thought that was a landing. It's actually, okay. How much would you have to shift your project in order to be conforming?
I did a calculation that if I pulled it back 1 foot to allow her 3 feet deep instead of 4 feet on the interior, it would have to be the bare minimum. That's the minimum for a hallway by code. So if we did that, we would still be encroaching 9 inches into
Okay.
that space.
What if you shifted the entire project?
We have stairs that comply,
The-
that
the-
compete with also
the-
on the other side.
The stairs and the existing openings in the brick, we have this small target area to land on. And so we can't move the stairs, movable object.
Can
you
you,
show that-
can you point to that?
Yeah,
What stairs are
Yeah,
we
go
talking
to
about?
the plan. The plan.
it was up a minute ago. It was just up. There you go.
There you go. So you see the stair are just down from the yellow highlighted vestibule.
Yes.
There are some stairs that go up and stairs that go down to the basement. And there's a door there that's there existing. We can't move
I guess
any of
I'm totally
that.
confused.
I don't see why you can't move it.
So the stairs right in the middle.
Uh-huh.
You have a pointer?
No,
Yeah.
I just,
Okay.
I'm looking,
Oh.
we're all looking.
So
If you move that a foot in,
see the kitchen go down to the 6 o'clock position. You see an up arrow
right?
right
Okay,
there.
we're talking about the internal stairs, right?
Yeah.
So you're circulating around those stairs. There's an existing door in the brick
Right?
and
That,
this,
But if,
you can't move that piece in because
but what if that whole, right, the whole family room moves over a foot?
Yeah,
I think that's what Ms. Malice is asking.
you shift, you just.
You shift the whole family
because you
room
have a
over.
step- You have a setback of 13 feet on
You
the
have plenty
other
of
side.
setback on the left.
no, but the
But it-
door, you cannot move the door in the hallway that goes to that
Right.
vestibule.
You have an existing doorway.
That's
an
an
existing
existing
house.
doorway. And if you move
No.
that, you block the doorway.
Okay.
You're only moving
All
a
right.
foot.
So,
No, but you can't,
You
the
can't.
doorway's right up against the wall there.
I
have a
see that.
chimney.
You're talking about the one that goes into the powder room
Yes,
Yeah.
that hallway, that door,
door.
if you move it over to
Yeah.
the
I
left
see that.
a foot,
okay.
you
that's,
don't have a
Gotcha.
doorway.
Yep.
and there's a,
And-
like, that's the stairs to the basement, that's the stairs upstairs, there's a chimney. So
It's
there's like
just tight.
dedicated structures that
Okay.
can't really move. And then the driveway is only in one spot. The garage is existing, right? That was there when the house was built. There's not many garages in the whole neighborhood. So that was a nice feature to buy on the property, which I'd love to be able to keep. So I'm kind of limited as far as what I could do. Most houses that have an addition go directly back, but that's not an option that I have. Where I did moved it, the whole addition as far over as I possibly could. But for safety reasons, for access to the home, to be able to still use the driveway and come into the back of the house, that is the only option that I have to come into the back of the home in that little
But
spot.
I mean, there are other options here though.
Yeah.
Right. So I don't,
Show me where the air conditioning unit,
It's right there to the
To the right
right,
of
the right
the
with the
yellow.
little circle.
okay, so you're saying that's an obstacle? Because you.
Well,
Well, but
it's
it-
costs a lot to move those. And
If you have moved it or not, that's within that 8 feet. So that's
Right.
not helping me at all. Like I wouldn't utilize that space because that's already within the encroachment.
we can't
Area.
move to the right
but you,
anyway.
you cannot, right, like, just, I mean, another example, right, there's the new deck that you're proposing on the back. You could put stairs going down from the deck, right?
Yeah.
You know, you can drop the yellow highlighted portion and have a stairs down from that exit and a second exit from the family room, right? Only point I think that Ms. Malice and I are making are that there are other options here.
Yeah, and I'm just intrigued by the previous ones that have been approved and with 6 feet and granted another neighborhood and the 6.5. And so I'm just, there are not a lot of garages in this neighborhood. We've reduced it to its smallest possible size for code approval. And we are 1.5 square feet encroaching.
I was also looking at a 2-story addition, so I can have an entrance into the back primary bedroom as well, but I minimized that to 1 story because I didn't want to have to work with that because that was also more encroachment. So I was trying to be mindful of that, making it 1 story versus 2. Different from what you have in the application, I have support of all of my neighbors, but 2 that I was not able to connect with. They weren't interested in communicating with me, so I have all of that. If you'd like to have that, they were all in support of the addition. They didn't feel that it was going to impact them at all. It wasn't going to be something that was different from what you see in the neighborhood.
Do my colleagues have any further questions for the applicant?
I mean, one of the things I really loved about Arlington Forest was the actual neighborhood itself, and I'd like to keep the property as close to what it looks like. You know, I don't want to make any excessive, big, grand homes that don't look like Arlington. Like, I would like to keep it similar to what it is, and this is such a minor, minimal part of the home that would allow me to be able to use it, you know, very close to what it is, but hopefully have my parents live with me one day if they need to.
Thank you. Colleagues? Ms. Freshman, would
I'm okay with it.
you like to try a motion?
I think they've made a good faith effort to keep the garage. You could say whack a foot off the garage, I suppose, but I think it's minimal and not offensive. I will move. In case V-12091-25-UP1, I'll move the alternative resolution for approval as advertised with conditions.
Second.
A motion, a motion for the alternative resolution as advertised, made by Ms. Malice, seconded by Ms. McCoskey. Is there any further discussion?
I'll just
McCoskey.
comment. My view is that this is a very minor incursion, and the applicant has made substantial efforts to minimize it, and I think it's just not going to affect much else except for this property. And so I just don't see why this isn't a place where we can allow a little bit of incursion.
Thank you. Did you have, Ms. Freshman?
Just clarify that I made the motion. I thought you said Ms. Malice made the motion.
I'm sorry. I can't hear you.
Freshman made the motion.
Did I not say that?
I don't know.
I don't remember.
Well, I will correct.
So you did smell. So
Oh,
Ms.
well, I will
Freshman
correct the
just
record to Ms.
clarified.
Freshman, right. Apologies. if I
That
did
way I won't have to correct the minutes.
No.
Mr.
Ms.
Chairman.
Malice.
Yeah, I will support this, but I just do want to comment just for the future. You know, BZA precedents, we look at things case by case. So try not to weigh us down with precedents too much because each situation is different. And we take different things into account.
Yes, I understand.
And I will just add that I would typically not be inclined to support this, but this is really shielded from view. It's really, you know, on almost all 4 sides, except for a sliver. So that's all I'll say. Hearing nothing else, I will call the roll. Ms. Malice.
Aye.
Ms. Freshman.
Aye.
Ms. McCoskey.
Aye.
Mr. Kumana.
Aye.
Chair votes aye. Motion passes 5-0.
Thank you.
Again, the long way, but we got there. Ms. Klein.
Case number V-12092-25-VA-1, a variance request by Tag Lunger of Arlington Land Use Group on behalf of CR Management Group LLC, the owner, to create a new lot with a width of 37.5 feet instead of 60 feet as required, and a lot area of 50 square feet instead of 6,000 square feet as required in the R6 zoning district regarding the creation of a new lot for the development of a one-family detached or dwelling in the R6 zoning district on the premises currently known as 3111 19th Street South, Lot 90 and part of Lot 89, Green Valley. Staff recommends that the board adopt the attached proposed resolution denying the variance request. An alternative resolution has been provided to the BZA see fit to approve this variance request as advertised. And please note that we do have additional speakers who have signed up to speak on this item.
Thank you. Has there been any feedback on this from neighbor outreach? I don't think I saw that in the application.
Staff have not received comments from neighbors other than what was provided in the application submittal. I will indicate that when I went out to post placards, I did get questions from people driving by, but nothing that resulted in a comment.
Okay, well, I'll follow up when I call the applicant. I will follow up. I assume he does not have a petition or anything with him. Would you give that to staff then? And we could discuss later. Great. Do my colleagues have questions for staff?
I don't have questions. I have a comment, but I can
Right.
wait till the end
Okay.
if you'd rather.
The end as
I
in
guess
after the applicant or
my
before the-
general impression is that if these lots were already subdivided, the houses aren't asking for any exceptions. And unlike a lot of my colleagues, we've already been down the road with EHO, but basically Arlington's done a pretty poor job of increasing housing stock and dealing with affordability. So I'm inclined to support it, but I'm happy to hear everybody else's comments because I know that mine is probably not the prevailing opinion.
Any questions for staff? Thank you, Ms. Frischman. Ken, I just wanted to ask, I don't know who wrote, Ms. Klein is talking, so I'll wait a second. I have a question for staff. Sorry.
Note that there's one copy of what they provided instead of the usual, so I'm just going to pass it along and everyone can look at it and then, yeah.
Okay.
Thank you. Ms. Klein, can you just give us a quick the current status of these lots?
Yes.
What, whatever details you have would be great.
Yes, so as currently, there are 3 quote lots originally created in 1914 or as identified in the deed book in 1914. They're lots number 88, 89, and 90. Currently, they're all under one ownership. There's a period of about 6 years in the 1920s when they were not all under one ownership. That's the record that we have that indicates the only time that they weren't under one ownership. During that time, however, the 2 lots 88, 89 were under the same ownership and a single family dwelling was constructed atop those 2. It straddles those 2 lots together. And then the third quote lot is lot 90. And that was then purchased by the owners of the other lots in 1931. And they've all been held under common ownership since that time. The pursuant to Article 16 related to nonconformities of the zoning ordinance, despite that lot being undersized, if they would like to pursue some type of construction, it is technically considered a buildable lot despite the undersized nature of it.
90, just 90?
Say again?
Just lot 90.
Correct.
Right.
But based upon the current built environment.
And so 88 and 89 are considered one lot at the moment?
They are held under one RPC, one parcel number. It would require further determination from a zoning administrator determination to determine buildability. Correct.
And that's when the magical date of June 15th, 1950 comes into effect, right? Lots held under one ownership at that time.
Correct.
Okay.
So unlike 90, 88, so can 88 and can a single family home be built today on 88 and 89 without any further determination?
That would require
a determination.
a determination, I believe. I'm not able to answer that
Right.
question immediately.
And
But there is it is an existing condition right now. I'll
right,
say that.
it's existing, right. Okay, and so my obvious follow-up to that is uh, then 88 and 89 would not be subject to the same benefit as 90, right? So separate houses cannot be built on 88 and 89, or is that also a determination that needs to be made? Getting to Ms. Freshman's
That
comment.
is another determination that needs to be made. I will just note that under the EHO, there is an opportunity to build multiple units regardless.
No, that's right.
If all three are together. What's the?
Yeah.
What's the minimum lot size?
What's the frontage? Are you talking?
What's the minimum frontage for an EHO?
Well, I have that number.
You have
That's
that.
the- In an R6, you have to have 60 feet.
Yeah, 60,000. It's just like, yeah.
Right,
So-
right. So they all three would have to be
If you had all
Right.
three together, you could do it.
right. Right. So we'll hear from the applicant, but in following Ms. Freshman's tradition started tonight, I think this is all premature to me. We don't know a lot of the answers to these questions to be able to determine hardship for a variance, right? We don't know what the options are here. Other than an EHO could be built on all three under
If
question
they're,
for staff.
if they're
Current-
consolidated.
Can you update zoning's opinion on current EHO status? Are new EHO permits being approved? Because that is,
Yes.
okay, right. So there are other options here at the moment that this applicant can choose to do. And there may or may not be other options available to this applicant. So we'll hear from the applicant, but my concern is that I'm having trouble with the hardship part of a variance, which is required under Virginia code
So at a minimum, a single family home can be replaced.
at a minimum.
And-
Well, we don't know.
Yeah, we do.
Well, Ms. Klein said that is the current status, but that would require a zoning determination.
Or further analysis of the zoning code. We didn't prepare. I can look into that.
We don't know
but-
the answer to that.
Yeah.
Technically.
But there's enough square footage and frontage for a single family home.
Correct.
I'm sorry, but there's not enough square footage and frontage if you only count 88 and
Right.
89.
Right.
Okay.
Agree.
There is not enough square footage and frontage with 88 and 89.
To be able to build by right,
You need,
unless they determine that it's a lot, a pre-existing lot.
Well,
Because that,
but that's
those
50 feet.
two
What's the
together,
minimum frontage? Is it 60 feet in an R6?
60
60
feet
feet.
and 6,000 square feet.
But there might, but with a zoning determination, right, so we don't know the answer to this
Correct.
question yet, right? So my view is at the moment that this is all premature. The granting of a variance is premature because we don't know what the hardship is. But let's hear from the applicant. Unless anyone else has anything to add or additional avenues of question. Come on down. All right. Well, Ms. Klein.
Can I just note quickly, that under section 16.1.1 related to nonconformities, that section that you were referencing, that 1950 section, because 88, 89 were held under one ownership in 1950, it's our understanding that they would be able to be rebuilt. Stephen was able to clarify that while we were
Okay.
discussing.
Right. And so that even further.
Mhm.
Okay, go ahead.
Okay, so good evening, Chairman Kaplan, members of the board. Good to see everybody again tonight. My name is Tad Lunger, for the record, with the Arlington Land Use Group. The case before you presents two related but distinct questions. One, do three separately platted lots retain their independent legal non-conforming status despite a prior house having been built across internal lot lines? And two, if so, may the board grant limited dimensional variances to allow these three unusually narrow lots to be replatted into two more functional, less non-conforming lots? These are narrow legal questions. They are not policy debates. They are not requests to increase density. They're about how the ordinance applies to lawfully created property. The ordinance definition of a lot controls. Arlington defines a lot as a designated parcel established by plat or subdivision and having lawful frontage. That definition is dispositive. A lot exists because it was established by recorded subdivision. It does not exist because of how it is used. It does not cease to exist because of how a structure is placed. Each of these three parcels was lawfully created by recorded plat, provided lawful street frontage. These lots were never vacated, and they were never consolidated by recorded subdivision. Under the ordinance's own language, they remain three distinct individual lots. Only subdivision law can eliminate lot lines. Under Virginia Code 15.2.2240 at sequence, lot configuration is governed by required subdivision procedures. Platted lot lines cannot be erased without a recorded consolidation plat, a boundary line adjustment, or a formal subdivision action.
I'm sorry, let me interrupt. So are you arguing that they are three individual lots right now?
That is correct.
So it seems to me that this discussion then is premature and that you should get that determination from the zoning administrator before we move forward.
This determination was made in the staff report after our meetings with staff. So this issue was presented between the staff report and us coming here tonight. This was not an issue that was flagged us before this hearing, except through the staff report.
I'm sorry, I don't understand the answer. It's,
So this is,
the applicant, so step one is the applicant is arguing that there's a, oh, that's not for us. The applicant is arguing that these are three individual lots. And so Ms. Klein said that that had to be a determination that zoning would make.
and
That determination has not been made, as far as we've been told by staff, that determination has not been made by staff yet. And so I don't want to get into a debate of,
it's been made.
I don't want to get into a debate of whether there are three lots or not lots, because we don't know if staff agrees or disagrees with that.
He said that, he just said it had been made.
But Ms. Klein said that it had not been made to us.
No, what we got, so that information had not been communicated to us. That position had not been communicated to us except through the staff report prior to this hearing.
So you were not aware.
And so we are responding to what we received in the staff report, which had not been discussed with us prior to
Okay,
this
but
hearing.
do you agree that a determination should be made?
I don't believe there's any question that these are three existing non-conforming legal lots. Simply,
Well, there is a question.
it's not a question under the zoning ordinance. It is
I
not.
don't think that question is ripe for us, right? And
Right,
that's my
that-
problem with these variances is
Right.
I don't think they're ripe for us to make a determination because of the hardship requirement we have to make.
Yes,
Well,
but
we can, sorry.
yes.
We're cutting into your time, so we'll give you.
Yeah, we'll get, yeah.
I think you paused your time.
Yeah.
Okay.
Okay.
I mean, we can make a decision regardless of, based on whatever information is before us. We're not required to.
Yeah, but
We can talk about it after I've talked, and then maybe we can come to some sort of
yeah,
resolution.
and right, and I assume now then the next part of where you're about to go is then why this determination matters to us, right?
Right.
Why is three lots important versus 2 and 1?
That's right.
Okay,
Yes.
right. No, so I think my position is clear, right? So,
Right. Well, so only subdivision law can eliminate lot lines. Okay. Under Virginia code, including the county zoning ordinance, under Virginia code 15.2.2240 at sequence, lot configuration is governed by required subdivision procedures. Platted lot lines cannot be erased without a recorded consolidation plat, a boundary line adjustment, or a formal subdivision action. None of that occurred here. The land records still reflect three separate parcels. Zoning regulates use and structures. Subdivision law governs boundaries. Zoning interpretation cannot override recorded subdivided lots. There's no express merger provision in the Arlington County zoning ordinance. For the county's position to prevail, there must be clear ordinance language stating that contiguous substandard lots under common ownership automatically merge and permanently lose independent buildability. There is no such language. The ordinance does not redefine a lot based on use. It does not state that constructing a building across lot lines extinguishes lot status. It does not provide that demolition fails to restore independent buildability or mandate permanent merger by implication. In Virginia, zoning ordinances are strictly construed against the locality. Property rights, including non-conforming lot rights, cannot be extinguished by inference. The prior use did not amend the plat, record a consolidation, or legally merge the parcels. It reflects only a temporary development choice. That structure is now being proposed to be removed. There is no ordinance mechanism converting a temporary unified development into a permanent loss of legally created lots. The practical hardship of 3 unusually narrow lots. Although the 3 lots remain legally independent, each is so narrow that it cannot reasonably accommodate a compliant single-family dwelling envelope under current dimensional standards. The hardship arises from extreme and unusual lot narrowness, modern dimensional requirements adopted long after the lots were platted,
30 seconds remain.
the physical configuration of the land itself, and this hardship is tied to the property, not to the applicant. It is not a general county-wide condition. It is specific to these legacy lots located in a historically African-American community. The proposal reduces nonconformity. Rather than attempting to construct 3 constrained dwellings, each requiring substantial relief, the applicant instead proposes replatting the 3 lots into 2 wider lots, creating parcels materially closer to lot width and area standards, reducing overall dimensional nonconformity, and the proposal reduces potential density from 3 homes to 2, improves functional building envelopes, produces development identical with surrounding properties, advances the intent of the ordinance. The board is not being asked to intensify development. The board is being asked to allow a configuration that is more orderly and less nonconforming. The variance standards are satisfied. The requested dimensional variances meet Virginia standards. The hardship is physical and unique. It's not self-created, and the relief is the minimum necessary. Substantial justice is served. The granting relief eliminates the practical difficulty posed by 3 functionally unusable parcels, produces a more conforming development pattern, avoids forcing overbuilt structures on extremely narrow lots, moves the property closer to the ordinance's purpose. Denying relief would either leave 3 unsuitable lots or require more intense variances later. Approving the 2-lot configuration is the more balanced and more orderly outcome. So in summary, 3 lots were lawfully created by recorded plat. They were never legally consolidated. The ordinance defines a lot by subdivision, not by use. No express merger language mandates permanent unification. The prior structure did not eliminate lot status. Accordingly, the board should recognize the continued independent legal status of the 3 lots. And because their extreme narrowness creates a unique physical hardship, we respectfully request approval of the limited dimensional variances necessary to replat them into 2 more improved conforming lots.
Thank you.
Thank you.
Ms. McCoskey.
Yeah, so I just have a couple questions. So first, there is the equal housing, or what is it called? The EHO process is available to you. I understand there's lots of questions about that, and it's very uncertain given the court's involvement and everything else, but that is theoretically an option that you would have to pursue, correct?
Correct. This project was actually envisioned to be an EHO process,
Right.
and this applicant had done substantial amount of due diligence prior to going down this path, and had the rug pulled out of him in September of that year.
Right. Okay.
That being said, right now the status of the EHO litigation, it creates a practical impossibility of proceeding with that kind of development. The current holding on the merits for that case was that the county's actions were illegal. That case has been remanded to the circuit court based on an indispensable party procedural issue. So the court has ordered a retrial to add the Wilson Ventures party, but the case has not been overturned on its merits. The only holding we have today is that the EHO ordinance is still illegal on its merits. That indispensable party action has been appealed to the Supreme Court, which is due into the Supreme Court no earlier than April. If the county wins at the Supreme Court level on the indispensable party case, it goes back to the trial court, and the whole thing starts over again for a period of many years as it works its way back through the trial and back through the appeals process. If the plaintiffs win at the Supreme Court level on the indispensable party issue, then this goes back to the Court of Appeals, and they have to hear it on its merits and overcome the presumption of the trial court's correctness, which likely makes the ordinance illegal. Either way, no conventional lender is going to give my client the money he needs to finance this project. It's a gamble. Nobody knows what's going to happen, and it functionally and practically and realistically makes that path unfinanceable for us for a period of years or indefinitely.
And you could also you could today, if the house came down that's there, you could put a house on the 3 lots. You could use the 3 lots together.
We could, and so what we would be losing our right to be able to build 3 single-family homes. Those lots were created and they're grandfathered for a single-family home.
Right, but that's your choice to build 1 or to build 3. I mean, you could, I mean, I understand that it's practically those 3 homes probably wouldn't be something you'd want to build, but that's, again, like I say, those are options that are available. And I also, sorry, all right, so I'll stop for now, but I may have another one. Let me think, sorry.
And to speak, well, you are thinking, if it's okay, my client, he went door to door. And so he's met individually with all of his neighboring properties around, and they're enthusiastic about this option. You know, I think the preference is just to do the 2 homes. The 2 homes he's proposing, they'd be on about 5,250 square foot lots. They're modest 2.5-story bungalow kind of type of houses. They're a bit longer.
Right. Compatibility has less to do with a variance than it would be for a use permit. So I don't think that this board's going to be hung up on that.
Yeah. So, and my other, I remember what else I wanted to get to. So but we also have a situation where in this area, there are many of these small little, because that's how it was platted way back in the day. And yet it's zoned R6. So it's clearly not intended to be, you know, the plan for the area is not to use these little tiny lots. And there are single family homes throughout the neighborhood, right? So they're built across lot lines, and that's kind of how things have developed. But to me, it's hard for me to recognize this as a unique situation when the county board, you could ask the county board to go in and change the zoning. I have a lot of concern about allowing lots to be created, which are less than the minimum standard, when there are options. And you know, the county board hasn't adopted anything that allows for these smaller lots. I mean, I think that's kind of problematic for us to do by way of a variance when, you know, there are 3 lots. You could build across all 3. You could build across 2 of them and put 1 small house. There are options. I also think it's problematic that there's a legislative option. And I understand, you know, having been through lawsuits for many years, I mean, these things, they do create a lot of uncertainty. And that is where we are. But it would concern me to make these smaller lots as the answer to that, when it's not that there are no options. I think it's hard to meet the unreasonably restricts and hardship requirement when there are things that can be done with this property. But that may be something that we don't agree with, because I heard what you said about the hardship.
Well, and I think, you know, the Fairview subdivision in Green Valley is a different subdivision than the rest of the county. It was the row house subdivision that was planned for the African-American community to take the knock line from Green Valley to work in what was then industrial Roslyn. These were intentionally smaller row house style lots. And in 1950, when they rezoned this to R6, they took those rights from the owners of those lots. So things that were smaller, and it's the same sentiment we have today, things that were smaller and more affordable, you know, it was the ability to build smaller and more modest homes affected that community. And it's today, and again, this isn't a policy discussion, but this is an opportunity to take 3 of those small lots that were stripped of their ability to do what they were able to do at the time, unless variances are awarded. It's a total taking of the property rights. When you think about what a variance is supposed to be there for, you know, if we strictly apply the ordinance to these parcels, they have no development rights, right? individually, because each lot, according to Virginia law, stands on its own. You're taking the property rights from that parcel. It will never be redeveloped without some sort of relief valve here.
But we don't even know if that's the county's position, that each of these three are buildable, right? I mean, that was my question to staff at the beginning is, could a home be built in its existing condition now on 2 of the lots? Because then we're only talking about 1 of the lots, right? We just don't know. I don't think that's.
But then the county's confiscating a lot.
But I also think that's the problem is that is a area-wide problem that may need to be addressed, but that's not to be addressed by a variance creating lots that are substandard under today's standards. And I am concerned that we would violate the provisions that don't allow us to approve a variance for something that can be fixed by a zoning fix. And again, would be very concerned, and we've had other circumstances like this where there's a sympathy problem. I mean, it's not a problem. People are sympathetic to landowners who have difficulty for whatever reason pursuing some of their rights. And these are the rights that are chosen. If there are 3 lots, indeed, you can build 3 houses. Admittedly, they're small. They may not be what you want to build, but you still have the right to put 1 across all 3 or 2 plus 1 small one. And those options are available to you. So I just don't think that we'd have the unreasonable restriction problem.
But I do think that the point is well taken that when the zoning was slapped on that area, it was completely unrealistic with the existing lots. So to that extent, it creates some real difficulty for the landowners.
But can be corrected legislatively. Mr. Chairman? I am sympathetic to your client's position. EHO has been stressful, for a lot of people in a lot of different ways. But, development has risks. And unfortunately, this is one of them, when the ordinance becomes unclear or is challenged and you're caught in the middle of an uncertain situation. But
Miss, we have a speaker to hear from, so if you're drawing conclusions, I just wanted to.
Well,
go ahead.
What are we doing here now?
We have a speaker we have to hear from.
But are we asking questions or what?
Yes. I wasn't sure if you were going to your ultimate opinion. I wasn't.
I'll wait, but I wasn't, but that's okay.
Right. That's why I wanted to interrupt before we go too far along. We still have a speaker we haven't heard from.
Right. Okay. I'll wait.
Sorry. If there are no further questions for the applicant, let's hear from the speaker that signed up. Mr. Yoon.
Good evening. My name is Jason Yoon, and I'm living next to these properties. And I've been living there for 16 years.
I'm sorry, can you give us the address because we can look at it on the map?
3107 19th Street.
Thank you.
Okay. And then also next to this project down, there is a like estate sale too. So these things is going on and on in our neighbor. So our neighbor, except the one house, the frontage is about 60 feet. Every house, except the one, I think that was a long time, they put the 30 feet of, like when they put the like 3 lots of this size, there's only one house, there's an old house. Every house is over 60 feet of frontage. And then the problem is like, this, we allowed like a 2 house in this abnormal lot, it's a rectangular lot. And it's entirely different from any other house. It's kind of, we lose the characteristics of our neighbor. And if he's a president, and in the future, we're gonna have more trouble with this kind of problems because, and we still have quite few old house, like over 100 years of house. we are mixed up with every new house and old house mixed up. But still have quite a few of old house. But the developer usually want to come and split the lot and to make a two house like they are like a businessman. That's what they do. But I strongly object to, and I want to deny this kind of variance. It's kind of, I heard what she says kind of more logical. If they put the three house, they cannot sell it because of the so small shrink, including the like a setback. Like altogether is 80 feet, like a 60 feet. What the house is now is a 20 feet in the additional. So it's altogether 80 feet. If they split the three, then they cannot build a house at all. So I think she's right. It's either give a one house permit, or I don't think it's a right idea to give like a split the two house with this lots. Thank you for hearing me.
Thank you, Mr. Yoon.
So a lot is 35 feet.
Do we have a second speaker signed up?
My name is Hannah Yoon, and my husband just registered because he doesn't want to come alone. So I didn't really prepare it, but I just want to say, but I don't know about the zoning and numbers, but their lot is a little bit bigger than ours. But I was really looking forward to have new houses next because it's our that lot is very old house, is sitting there for almost 1.5 years. So I was really looking forward to have a new house, but I thought it's a single house. He dropped by, talked to me, so I was surprised it's two houses. The main concern is, I don't know if it is your Arlington Jones said is okay. I don't have an argument, but I just wanna, my concern is that is the entrance from the Glebe Road. There's lots of traffic in the 19th Street, but that our house is 4th house from the Arlington. And then, Glebe Road, and then his lot is a third one. It's already, the congestion is so bad, especially for the snow time. It was really, one car has to move back to go out the other car. So this morning, I just take a picture. It's this much car is there. And then I know if he built the two houses, maybe there is a one garage. As we have a 2 or 3 cars in. So already street is no parking lot. The reason is the first left building has almost 7 or 8 people living. Somebody built a multi-use big building, so they are rented out. So I think it's about 7 and 8 adults. So they parked in the street. So there is no parking lot. And then next neighbor is they do the daycare. So people in the morning and then afternoon, they come and park, they pick up the baby and then bring it. And then those traffic is so bad. So I don't mind their lot in the back, and then our neighbor is all single houses. So this is the picture
Thank you.
Thank you.
Oh, sorry. Do my colleagues have any further questions for the applicant or staff? Discussion?
I just want to make one additional point, which is, and again, we run into the issue of the EHO lawsuit, but it is also one of the other restrictions on our authority is when the relief or remedy sought by the variance application has to be not available through a special exception process. And I think we do have understanding all the problems with the EHO thing. I mean, I think that's out there, but the fact is that that is a special exception process that is available to the applicant that makes it more difficult for us to exercise our variance power.
Thank you, Ms. McCoskey.
Mr. Chairman,
Ms. Malice,
I'm prepared to make a motion.
please.
Was prepared. But I will say before I do that, it's really unusual that we get a staff resolution, staff recommendation that basically is is critical of the project on all the merits, all the standards. When I look at all the whereases, there isn't one that they can find that, you know, would support the variance. And I tend to agree with the staff resolution here that that this fails on a number of items. So I will make a motion to support to adopt the attached proposed resolution denying variance 12092-25-VA-1.
I'll second that.
A motion by Ms. Malice for denial as advertised, seconded by Ms. McCoskey. As advertised, is there any further discussion? I'll just add a couple of points that I don't think has been addressed yet. One is this applicant's taking argument I think is a little premature because we don't have a final outcome on the EHO option, and two, I think that there are other options that can be worked out with staff that may or may not be available to the applicant as well. So I know the applicant had made that argument in his presentation, and I wanted to address that. And you know, as I said previously, when the applicant handed us the petition, that, you know, it's a variance, so it has a little less weight than it would for a use permit. But looking through the addresses on the petition, the majority of these aren't even on the tax map, right? This is the 3000 block, and most of these are on, you know, 100 Aberdeen Street. So they're not the surrounding lots in question. I just wanted
This is a different app.
Oh, it's a different application.
Yeah, those are from the neighbors directly next to
Right.
right across the street.
They were from 117 South.
Apologies. I don't know how I did that. Okay, so hearing no further discussion, I will call the roll. Ms. Malice.
Aye.
Ms. Freshman.
No.
Ms. McCoskey.
Aye.
Mr. Kumano.
Aye.
Chair votes aye. Motion for denial passes 4-1. We have another one of these. I don't know how we can address like identical ones in the future, but it seems that we have to go through and hear from everyone and make the same arguments again for the record.
Case number V-12093-25-VA-1, a variance request by Tag Longer of Arlington Land Use Group on behalf of CR Management Group LLC, the owner, to create a new lot with a width of 37.5 feet instead of 60 feet as required, in a lot area of 5250 square feet instead of 6,000 square feet as required in the R6 zoning district, regarding the creation of a new lot for the development of a one-family dwelling in the R6 zoning district on the premises currently known as 3111 19th Street South, Lot 88 and part of 89, Green Valley. Staff recommends that the board adopt the proposed resolution denying the variance request. An alternative resolution has been provided should the BZA see fit to approve this variance request as advertised.
Mr. Lunger. Mr. Lunger? Tad? Do you want to, we have the second item before us, so if you want to just say that you're making the same arguments, we can do it that way, or you can say something else if you like.
You know, I will say one thing. I think that for future BZA cases, I think it's troubling to have a purported determination issued in a staff report a couple of days before a hearing where we are forced to address something that the board hasn't been educated on. We have not had the opportunity to discuss in detail with anybody. And we're up here tonight trying to explain to you all what the law is, which we're very confident that these are buildable lots. It's nobody in this room can show me a section in the zoning ordinance that says a merger happens when you build across a lot line. The ordinance simply does not work that way. Okay, and so we're now here tonight making decisions based on an uninformed board and a supposition that was put in the staff report that we weren't communicated to about before the hearing, except through the staff report. That's, I don't think, a good way to do business here.
Okay, yeah,
Go ahead.
we hear you.
The additional speaker has left the room.
Yes.
Yeah.
I just,
Yes.
for the record, right, so I would call the speaker, but he is not here. And I will also make it just a statement that we can incorporate our previous discussion into this case because the facts are substantially similar.
Yeah.
I don't know if anyone wants to say anything about the applicant's comment.
No,
I mean-
I don't think that issue coming up, I mean, issues come up. I've raised a few red herrings tonight. The issues come up that are not
Jermaine.
presented necessarily. It happens all the time. And I don't think that would have made any difference to our decision making, but I think we should hear what the applicant says. We do our best to get everything out and open as early as we can.
And I agree. I'll add that the applicant was always free to have asked for a deferral for further briefing to us or further determinations from the county. And as you know, as I had said in a previous case, that perhaps that could have been brought to us as an appeal if a determination had been issued by the county that this applicant disagreed with. Then that would be, in my mind, a more appropriate venue for those issues to be fleshed out as opposed to brought before us in a variance. Ms. Klein, did you want to add anything on county's behalf?
Staff would just like to note that staff does not believe that a determination as to the number of lots was written in the staff report in the way that is purported by the applicant and indicating that a determination was made. Staff does not believe a determination was made in the staff report and would just like that to be noted.
And I had, if the applicant were here, I would ask for more point us to where in the staff report that was, because that was not my reading when I read either, but we don't need to drone on. So Ms. Malice, would you like to make a motion?
I move that the Board of Zoning Appeals adopt the attached proposed resolution denying variance V-12093-25-VA-1.
A motion for denial as advertised by Ms. Malice, seconded by Ms. McCoskey. Is there any further discussion? Again, I'm just going to say incorporating our last substantially similar 120.92-25-VA-1 into this record. Hearing no further discussion, I'll call the roll.
Aye. Oops, sorry.
Ms. Malice.
Aye.
Ms. Freshman.
No.
Ms. McCoskey.
Aye.
Mr. Kumana.
Aye.
Chair votes aye. Did you vote aye on this one?
Sorry.
She
How did-
voted no.
She voted
No.
no. Okay, I heard aye.
I'm nothing if not consistent. I move approval of the minutes from the January 21, 2026 BZA hearing.
Second.
Approval of January minutes made by Ms. Freshman, seconded by Ms. Malice. Any further discussion? Hearing none, I will call the roll. Ms. Malice.
Aye.
Ms. Freshman. Ms. McCoskey.
Aye.
Mr. Kumana.
Aye.
Chair votes aye. Motion for minutes passes 5-0.